Hey everybody, Anthony the crypto lawyer here, and today we're going to be finishing up the Ripple Labs SEC order from July. We have just a little bit left. This is the fourth video, so if you haven't seen the other three, pause this, check it out, start from the beginning. They're quite long, but we go through it line by line, so you'll know exactly what it is in there instead of having to rely on other people to interpret it for you. So let's jump on in. Okay, here we are. We left off right here on page 27 of the opinion, section 4. This is Larson's and Garlinghouse's offers and sales. So this is relating to the individuals, not Ripple itself. So it's not extremely important, but let's, for drama's sake, let's find out what's going on with Brad Garlinghouse and Mr. Larson. All right. Lastly, the court addresses Larson's and Garlinghouse's offers and sales of XRP. Section 4A1 of the Securities Act exempts transactions by any person other than an issuer, underwriter, or dealer. The SEC argues that this exemption does not apply to Larson and Garlinghouse because they are affiliates of Ripple, and an affiliate of the issuer, such as an officer, director, or controlling shareholder, ordinarily may not rely upon the Section 4A1 exemption. Cleaned up. I don't know what that means, but I guess what is being stated here is that there is an exemption in the Securities Act. And if you haven't heard my other videos, I am not a securities lawyer. So this stuff, I'm learning it sort of along with y'all and giving you sort of my generalized attorney knowledge. But from what I gather here, there's an exemption to the requirement of registration for a transaction, I guess. So there's some sort of exemption that would seem to suggest that Brad and, Mr. Garlinghouse and Mr. Larson can use here. And the SEC is saying, well, no, because they're insiders. They're too close to the upper echelon of Ripple. They can't use that exemption. The court says it doesn't need to reach this issue. So it's not even going to decide the question. Like Ripple's programmatic sales, Larson's and Garlinghouse's XRP sales were programmatic sales on various digital asset exchanges through blind bid-ask transactions. So what she's saying here is, hey, what we talked about for Ripple's, quote, programmatic or algorithmic sales, we're going to use that same reasoning here and find that Garlinghouse and Larson's sales do not constitute unregistered securities transactions. So that's good. That's good for them. And ultimately, she's relying on this reasoning that the people who were buying them from Garlinghouse and Larson didn't know they were buying them from Garlinghouse and Larson. So they had no expectation at all that Ripple would be helping them increase the price of their investment, other than generalized market forces. So Larson and Garlinghouse did not know to whom they sold XRP, and the buyers did not know the identity of the seller. Thus, as a matter of law, the record cannot establish the third Howey prong as to these transactions. For substantially the same reasons discussed above, supra, which is a fancy Latin way of saying the above section here, point 2b2, Larson and Garlinghouse's offer and sale of XRP on digital asset exchanges did not amount to offers and sales of investment contracts. Okay. So that's good. That's good for them. Let's see what footnote 19 says here. For the reasons stated, the court need not address defendant's argument that Larson and Garlinghouse are entitled to summary judgment on offers and sales on foreign exchanges. I guess Garlinghouse and Larson had some sort of argument that relied on foreign exchanges, and the court said, we're not going there. I've already decided the issue. Okay, next section. That was pretty quick. Next section, defendant's due process defense. So this is the fair notice defense that was a big deal in the months and really the years leading up to this order. And we're going to see exactly how the judge handles it, because I actually really want to know myself. Defendants each assert a fair notice defense, claiming that the SEC violated their due process rights. Larson and Garlinghouse also assert an as applied vagueness defense based on the same due process principle. So what they're arguing here, from my understanding, is that how are they supposed to know that they were breaking the law if they reached out to the SEC and the SEC did not give them an explanation? They just said, hey, we don't know what the law is, but we know that you violated it, so you're getting sued. That seems a bit unfair. So let's continue. A fundamental principle in our legal system is that laws which regulate persons or entities must give fair notice of conduct that is forbidden or required. Fair enough. This clarity requirement is essential to the protections provided by the Due Process Clause of the Fifth Amendment and requires the invalidation of laws that are impermissibly vague. Laws fail to comport with due process when they, quote, fail to provide a person of ordinary intelligence fair notice of what is prohibited, or, two, are so standardless that they authorize or encourage seriously discriminatory enforcement. This assessment cannot be conducted in the abstract. Rather, the party claiming a lack of notice must show that the statute in question provided insufficient notice that his or her behavior at issue was prohibited. So she's, it looks like she's quoting here to a previous document number. It must be a brief of some kind. The evaluation of any fair notice defense is objective. An objective, again, as we talked about in earlier videos, means it's not how any person specifically, like Garlinghouse or Larson, what they actually believed. You kind of base it on this mythical, reasonable person who it's a really amorphous standard, but you kind of just think of what would a reasonable person in the same shoes as Larson and Garlinghouse, what would they have thought and what would they have done? And what are the attributes of that reasonable person? It's kind of just up in the air. Ultimately, it's really just whatever the court thinks. That's kind of a cop-out way of putting it in the court's hands. So the evaluation of any fair notice defense is objective. It does not require inquiry into, quote, whether a particular party actually received a warning that alerted him or her to the danger of being held to account for the behavior in question. Already by the tone of this, I can kind of tell that she's not going to rule in Larson and Garlinghouse's favor, which is I would find surprising, but let's see what she says. It's a citation, footnote 5, quoting some things here. Yeah, okay, here we go. The court rejects defendant's fair notice and vagueness defenses as to the institutional sales. First, the case law that defines an investment contract provides a person of ordinary intelligence a reasonable opportunity to understand what conduct it covers. She's saying Howie sets forth a clear test for determining what constitutes an investment contract. And Howie's progeny provides guidance on how to apply that test to a variety of factual scenarios. I really disagree with the court here, but, I have no power at all. So it's her decision. C. Smith, it's not only the language of a statute that can provide the requisite fair notice. Judicial decisions interpreting that statute can do so as well. That is constitutionally sufficient to satisfy due process. So she's saying, hey, that Howie case and all the cases that further define the principles espoused in Howie, that's clear enough for you to have known whether your institutional sales were legit or were violating some sort of securities law. I really disagree with that. There's no, it's not clear. It really is not clear whether cryptocurrencies, would constitute securities as they have been used. I mean, obviously in hindsight, she's suggesting that it's clear, but at the time, it's certainly not clear. So the way that she's saying that Howie provides a clear test, I really just disagree with that. But, I'm not the judge again. United States versus Zaslavsky. Quote, the abundance of case law interpreting and applying Howie at all levels of the judiciary, as well as related guidance issued by the SEC as to the scope of his regulatory authority and enforcement power provide all the notice that is constitutionally required. Not going to say much more about that, honestly. I just, whatever. Second, the case law articulates sufficiently clear standards to eliminate the risk of arbitrary enforcement. Howie is that is absolutely not true, because SEC is just going around suing everyone right now. Everyone in the crypto space is getting sued by the SEC. So isn't that evidence that there's some arbitrary enforcement going on here? I don't know. Howie is an objective test that provides the flexibility necessary for the assessment of a wide range of contracts, transactions, and schemes. Defendants focus on the SEC's failure to issue guidance on digital assets and its inconsistent statements and approaches to regulating the sale of digital assets as investment contracts. Wholeheartedly agree with that statement. But the SEC's approach to the enforcement, at least to the institutional sales, is consistent with the enforcement actions that the agency has brought relating to the sale of other digital assets to buyers pursuant to written contracts and for the purposes of fundraising. Yeah, that is after the fact. That is way, way after the fact. Ripple started doing this. I mean, I think they were one of the second crypto companies in the space, maybe. And you know, these institutional sales happened long before any of these cases had come to fruition. So I just don't agree with it. It's all hindsight is what she's relying on here. Let's see what footnote 20 says. Because the court finds that only the institutional sales constituted the offer and sale of investment contracts, the court does not address defendants' asserted fair notice defense as to the other transactions and schemes. The court's holding is limited to institutional sales because the SEC's theories as to the other sales in this case are potentially inconsistent with its enforcement in prior digital asset cases. Okay, so she's saying, hey, the only sales that I found to have violated the securities rules is the institutional sales. So I'm only going to address the fair notice defense as to that type of sale at issue. And she's not going to address it with the other ones. Again, she's really narrowing the scope of her order. And I guess it's because she's really trying not to be reversed on appeal. So let's keep going. Moreover, the law does not require the SEC to warn all potential violators on an individual or industry level. Courts ask whether the law presents an ordinary person with sufficient notice of or the opportunity to understand what conduct is prohibited or prescribed, not whether a particular party actually received a warning that alerted him or her to the danger of being held to account for the behavior in question. If that is actually the case law, which I assume it is, it's a quotation from this case, I think that's a really sad state of affairs, honestly. The law does not require the SEC to warn all potential violators on an individual or industry level. Well, then the SEC should just completely get out of the business of providing any guidance at all. They should not even entertain questions from anyone about anything. They should just do the enforcement. I mean, it's just sends mixed signals when you can go to the SEC for some sort of, regulatory guidance in other contexts, I assume. And not be afforded a fair notice defense here. Okay. Accordingly, the SEC's motion for summary judgment is granted as to the institutional sales and otherwise denied. So this is sort of a cleanup here where she's saying the SEC's motion, they had all these different points that they were trying to raise on different types of sales. The only ones that we are going to say the SEC won on are the institutional sales of, I believe it was roughly $700 million or something like that. All of the other ones are denied. And defendants' motion for summary judgment, so Ripple's motion for summary judgment and Larson and Garlinghouse, is granted as to the programmatic sales and other distributions, and Larson's and Garlinghouse's sales, and denied as to the institutional sales. So all in all, she's saying SEC loses on institutional sales, SEC wins on institutional sales, and defendants win on everything else. At least as to the programmatic sales, other distributions, and the individual sales by Larson and Garlinghouse. So all in all, that's actually a really great outcome For Ripple, I mean, they have some of their monies that they're going to have to probably pay some sort of fine on or whatever. I don't know. The institutional sales are going to have to account for some of that, but all in all, largely the court found that they did nothing wrong, and that's great. So anyone telling you otherwise, that this was a loss for Ripple, that is just you've read it for yourself now. Everything that um, Ripple was hoping to win on as to the larger market, effectively they succeeded, except for the institutional sales. So great for Ripple. Let's see this next section. Larson and Garlinghouse's aiding and abetting of Ripple's violations. So this is a way that people try to, lawyers try to add on personal liability to folks that can somehow be shielded through corporate veils and that kind of thing. So limited liability of the companies that they're working for. And I actually do this myself in my own practice. So let's see what she says here on this. But this is just sort of a secondary way. So aiding and abetting effectively means that you did something in your personal capacity to assist someone else in violating the law. And you can be held liable to the same extent as the person who actually did the quote unquote crime or the violation. So the classic example is if someone busts out of prison and you provide them a place to hide from the cops, well, you are aiding and abetting a crime. And you can also be punished for just hiding them. And so there's criminal versions of aiding and abetting, and then there's civil versions of aiding and abetting. So this is the civil side of things. The SEC also moves for summary judgment on its aiding and abetting claim against Larson and Garlinghouse. To establish liability for aiding and abetting a securities violation, the SEC must show three things: the existence of securities law violation by the primary as opposed to the aiding and abetting party. So that would be Ripple. So Ripple has to have violated something. Knowledge of this violation on the part of the aider and abetter. So that means that Larson and Garlinghouse must have personally known that Ripple was violating the law. And three, substantial assistance by the aider and abetter in the achievement of the primary violation. So that means that Larson and Garlinghouse had to have done something substantial or significant, large, impactful, in order to help Ripple violate the law. And that's pretty standard. As you can see here, that's pretty broad. And there's, you can get roped into a aiding and abetting liability. You can get roped into having aiding and abetting liability pretty easily. So let's see here. Courts cannot consider the three requirements in isolation from one another because satisfaction of the knowledge requirement will depend on the theory of primary liability. And there may be a nexus between the degree of knowledge and the requirement that the alleged aider and abetter render substantial assistance. So you can't just check the boxes here. You kind of have to look at it like a painting. You kind of have to sort of look at it all sort of together in a sort of a total macro view here of all three of these things. Indeed, courts have found that, quote, a high degree of substantial assistance may lessen the SEC's burden in proving scienter and vice versa. Scienter or scienter, however you pronounce that refers to knowledge of you doing something wrong. So what it's saying here is if you provide a substantial amount of assistance, then the SEC really has to a burden of proving lesser amounts of your actual knowledge. So if you just help out, you essentially do all of the heavy lifting to help Ripple engage in the violation. Well, even if you didn't know what you were doing, you can still be found aiding and abetting. Essentially, is kind of what that's saying. So the more that you help, the less intentional knowledge of violation you have to have. Okay, as to the first requirement, the court has already held that Ripple's institutional sales constituted the unregistered offer and sale of investment contracts in violation of Section 5 of the Securities Act. So that's the first prong, this one here. That has now been proved, as she talked about earlier in the opinion. So let's move on to the next one. With respect to the second element, to show knowledge of Ripple's violations, the SEC must demonstrate that Larson and Garlinghouse had general awareness of their overall role in Ripple's illegal scheme. And she cites a bunch of different opinions here, a case, a Dodd-Frank Wall Street Reform and Consumer Protection Act, public statutes, this and that. So here we go. The SEC need not demonstrate that Larson and Garlinghouse were aware that Ripple's transactions and schemes were illegal. Rather, so that's not good for Garlinghouse and Larson. They don't. SEC doesn't have to show that they had specific knowledge, effectively, that that what Ripple was doing was illegal. Rather, the SEC must show that Larson and Garlinghouse knew or recklessly disregarded the facts that made Ripple's transactions and schemes illegal under statutory and case law. So that's a bit easier for the SEC to prove than this first statement here. So Larson and Garlinghouse didn't have to know that the transactions, violated the Howey test. They just had to have known the facts that made up the transactions themselves. So, like, did they know that these contracts were being entered into with these institutional buyers? And did they know that the institutional buyers, for example, had lockup provisions in their contracts? That side of thing, that sort of thing. So let's see what the court says here. Based on the record, defendants have raised a genuine dispute of material fact as to whether Larson and Garlinghouse knew or recklessly disregarded the facts that made Ripple's scheme illegal. That's great for Larson and Garlinghouse. What that means is it's not clear one way or the other whether Larson and Garlinghouse knew the facts that made Ripple's scheme illegal. So it's not clear whether Larson and Garlinghouse were aware of the substance of the contracts, that sort of thing. And although it's not technically a win for Larson and Garlinghouse, what it does is it saves them from having that issue being decided right now on summary judgment. And instead, that will be an issue for a jury. So case is still going to go forward to a trial, at least based on this order. I think there's been some things that have happened since this order, and I'll go through that in the next video. But at least as of the date of this order, there is a trial going forward for Larson and Garlinghouse, and whether they are going to be found liable for aiding and abetting Ripple's violation. It is not clear whether Larson and Garlinghouse knew or recklessly disregarded that securities laws, rather than laws under other regulatory regimes applied to XRP. For instance, Larson and Garlinghouse testified that they did not believe XRP was a security because multiple foreign regulators, including regulators in Japan, Singapore, Switzerland, the UAE, the United Kingdom, had determined that XRP was not a security. So, okay, so that's where their knowledge was colored, was by the determinations of other countries. Larson and Garlinghouse also stated that when the U.S. Department of Justice and the U.S. Treasury Department's Financial Crimes Enforcement Network labeled XRP a virtual currency in 2015, they understood this as an official United States government declaration that XRP was a currency and exempt from U.S. securities laws. Okay, what they're saying here, Garlinghouse and Larson are saying, hey, there was just conflicting evidence, and there was sources telling us that XRP, official government sources, both from the United States and from other countries, that XRP was not a security. So we honestly believe that XRP was not a security, and therefore we were not violating securities laws. That's important for aiding and abetting. Larson further testified that he understood the 2018 speech by the then director of the SEC Division of Corporate Finance, Bill Hinman, in which he stated that neither Bitcoin nor Ether, another digital asset, were securities, to further reinforce the SEC's position that XRP was not a security. So this is all sort of Larson and Garlinghouse's explanation for why they didn't believe that XRP was a security. And this is enough to have them succeed in basically getting past the summary judgment stage. Okay, the October 2012 Perkins Coie Memorandum, which Larson reviewed, advises, although we believe that a compelling argument can be made that XRP tokens do not constitute securities under the federal securities laws, given the lack of applicable case law, we believe that there is some risk, albeit small, that the SEC disagrees with our analysis. Larson testified that after receiving the memorandum, Ripple took specific steps to ensure compliance with the advice contained within the memorandum. So they're being told from various different sources that XRP was really not a security. Likewise, defendants have raised a genuine issue of material fact as to whether Larson and Garlinghouse knew or recklessly disregarded facts about each of the Howey elements. For example, defendants have adduced evidence that Larson and Garlinghouse did not know that Ripple's institutional sales of XRP satisfied the Howey common enterprise element because they did not believe that the proceeds from the sales were pooled and understood that Ripple did not manage, operate, or control the XRP ledger or the broader XRP ecosystem. Based on the disputed facts in the record, therefore, a reasonable juror could find that Larson and Garlinghouse did not know or recklessly disregard Ripple's Ripple's Section 5 violations. That alone is sufficient, but she goes on to the third requirement here. As to the third requirement of aiding and abetting, defendants concede that Larson, as Ripple's CEO prior to 2017, provided substantial assistance, and Garlinghouse, after becoming Ripple's CEO in January 2017, provided substantial assistance. However, Larson claims that he did not provide substantial assistance during his time as executive chairman of Ripple's board starting in 2017. So, I mean, they're admitting that they provided substantial assistance. That takes that off the table. Apparently, but I think there's a little bit of a nuance here. To satisfy the substantial assistance component of aiding and abetting, the SEC must show the defendant in some sort associated himself with the venture, that he participated in it as something that he wished to bring about, and that he sought by his action to make it succeed. In other words, the defendant must consciously assist the commission of specific crime in some active way. Here, Larson has raised a triable issue of material fact as to whether he provided substantial assistance beginning in 2017. So, yeah, Larson's saying that in 2017, when I became the executive chairman of Ripple's board, I wasn't able to provide substantial assistance because I wasn't, involved in any of us. Effectively, I wasn't singularly involved in the decisions that were being made. He wasn't the CEO anymore. So, so he's saying I could not have, quote, substantially assisted after I left the CEO position. And the judge is saying, well, that's going to be something for the jury. So we're not going to, find that you have, we're not going to issue summary judgment against you right now. We're going to let the jury decide that. Finally, the record establishes that starting in 2017, Larson moved away from a day-to-day operational role at Ripple. Exactly. That's what I just said. But after he stepped down as CEO, Larson also continued his role on the XRP sales committee, which approved Ripple's sales of XRP. The court concludes, therefore, that a reasonable jury could find that starting in 2017, Larson did not consciously assist Ripple's Section 5 violations in some active way. So she's leaving a little bit of an opening there for Larson to have some of his potential liability lessened by establishing a date upon which he really cannot be found to have aided and abetted. So that could be good for Larson. Nothing there for Garlinghouse to really fall back on in that way. Accordingly, the SEC's motion for summary judgment on the aiding and abetting claim against Larson and Garlinghouse is denied. So that's great. That means that at the very least, Larson and Garlinghouse are going to have an opportunity to convince a jury for this aiding and abetting claim. So let's hear. For the foregoing reasons, the SEC's motion for summary judgment is granted as to the institutional sales and otherwise denied. So again, SEC just won on a single point in the entire opinion. Not good outcome for SEC. Defendant's motion for summary judgment is granted as to the programmatic sales, the other distributions, and Larson and Garlinghouse's sales, and denied as to the institutional sales. So ultimately, it really was a major win for Ripple. They didn't win at all, but I would say they probably won like 80% of everything in the case. So let's see what else. The court shall issue a separate order setting a trial date, and related pre-trial deadlines in due course. The clerk of court is directed to terminate the motions at ECF's blah, 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 blah. So these are different document numbers. So all of the motions will be terminated. I guess that's a thing that's done in New York. And this concludes the 4-part video series on this very hefty, very impactful order on the Ripple case. And I know it's been a while since, I really could have made these videos a little bit sooner, but work got in the way. But I'm going to go through the latest things that have been happening and get an update on that stuff, because I think it's pretty interesting. All right, guys. See you in the next video. Take care now. Bye-bye.